Well, hi everyone, and welcome to the video legal podcast, Legal Questions and Answers in Layman's Language. And our topic tonight is premises liability, slip and fall cases. And I think it'll be a very interesting and informative podcast. Well, hi everyone, I'm John Deary, and we are very pleased and thank you very much for being here. Our law firm that we'll be talking with today is the law office of Stephen B. Kaufman in Bronx County in the Throgs Neck area. And I could not be more pleased. He's been a friend for many, many years. Steve, welcome and thank you so much for being here.
Thank you for having me.
It is my pleasure. So we're going to talk about slip and fall cases. And let's maybe begin by, how do you see the key elements of a slip and fall case?
First of all, I want to tell your audience something about you.
You do.
They have to understand that you voted and wrote for some of the laws that we'll be talking about. And then you and I used to talk about all these things when we rode up in your yellow Cadillac, listening to Patterson sing Irish songs.
Oh, sure.
I think you made me an honorary Irishman. But it's a pleasure being here with you.
Thank you,
and
Steve.
to talk about slip and fall and trip and fall.
Let's do it. You have such a broad range of experience. I think those that are listening are going to learn something about this topic. So let's start with the analysis of a slip and fall case.
I think that people, sometimes they make fun of these cases, which is unfortunate and wrong. People get hurt very badly because of a landlord's carelessness or an owner's carelessness, not maintaining their premises. A owner has a non-delegable duty to maintain their premises in a reasonably safe condition. That's one of the elements. If he breaches that duty, then somebody gets injured because of that breach, and they did not contribute to the accident, then that's compensable in court, and you could recover for damages for your injury. Many people have broken hips, broken nose. Frequently you have broken wrists, because when you fall, you put your hands out to stop the fall, and they wind up with what is known as a Colles fracture, a complicated fracture of your wrist. So landlords must maintain their premises. And a landlord could be New York City, or it could be a private landlord, and it's non-delegable. They can't say it's my tenant's fault. They have the ultimate obligation to maintain their premises in a safe condition. And if they don't do it, they're liable for the injuries you sustain.
When you talk about slip and falls, there are thousands of them out there depending upon the individual. But could you give a sense as to what the maybe 3 or 4 general major categories of slip and fall cases are?
Well, you have in the supermarket, because that's very interesting. When you go to a supermarket, I'm going to get a little technical, you're an invitee. You're welcome into that store to buy a product. When you walk in the aisles, your eyes are brought in to look at the displays. They want you to look at the displays. So you could be walking straight and looking at the displays, and somebody could have left a U-boat, which is an iron hand truck that helps them bring packages into the store. They could have left it in the middle of the aisle, and you can fall over it. And it's compensable. They can't say, well, you should have seen where you're going, when they're trying to get you to look at their products on the aisle. Another interesting thing is slip and fall in the banana peel. You always hear about the slip and fall in the banana peel. Well, in a way that's tricky. Let's say, hypothetically speaking, somebody takes a banana, peels it, eats the banana, and throws the banana peel on the floor, and 1 second later you fall on the banana peel. You can't sue the supermarket because they did not have notice of the banana peel. But let's say the banana peel was there for an hour, then they have what is known as constructive notice, and then you have a lawsuit. Notice is very important in all these cases. They could have caused and created the defect. They could have had actual notice. They could have known, the workers could have known that banana peel was in the aisle for 2 or 3 hours. Or they can have constructive notice, where it's there for such a long period of time that they had an obligation to remove the banana peel, whatever debris is in the aisle.
Talk about a classification of cases. How about people walking on sidewalks, as we all do every day, everywhere? Let's talk about the type of slip and fall cases, uneven sidewalks, and things of that nature.
Well, in New York City, there are many uneven sidewalks. You can fall on a sidewalk that could be one flag. That's the sidewalk. They call it a flag, the sidewalk patch. And that could be uneven for the other part of the sidewalk, and you can trip and fall. Now, here's the quirk. Under the Administrative Code, Section 7-210, the abutting landlord is responsible or owner for the sidewalks. However, if it's 1, 2, and 3 family, they're exempt and the city's responsible. So if you fall on that uneven sidewalk, let's say it's in Manhattan, you sue the abutting landlord. It could be Saks Fifth Avenue or Tiffany's, you sue the abutting landlord. If it's in the Bronx and it's a 1, 2, 3 family home that's owner occupied, not a commercial building, then you sue the city. Now here's the quirk with the city. You have to file within 90 days a notice of claim. If you don't file the notice of claim, you're out of business. You also have to start the lawsuit within 1 year and 90 days from the date you had the injury. Otherwise, you're out of the ballpark. That's against the city of New York. Normally, the statute of limitations is 3 years. So normally you have 3 years, but when you sue the city, you have to be alert to the notice of claim. That's a very important condition precedent to bring in a lawsuit.
You mentioned about notice. I think that's very, very important. So I think you should expand on that a bit.
Notice is vital. In order to be able to bring a lawsuit, you have to have what is known as notice. The property owner must have had notice that there was a defect or there was a substance on their floor. There are basically two kinds of notice, but I throw them cause and create. Let's say the property owner created a bad condition. Let's say they cemented a sidewalk and they left it uneven by 2 inches. They caused that. You don't need notice. Let's say somebody in the supermarket, the people complained that the aisle had a banana peel, or people complained there was water leaking from a refrigerator that caused other people to slip and fall. That's actual notice. But let's say nobody complained. You have to have what is known as constructive notice. That is easier with sidewalks, but in the supermarket it's more difficult because you have to have a certain amount of time elapsed. So they would have constructive notice. As I said before, with the banana peel, it can't be 1 second later because they don't know, so it's not their fault. They didn't have time to clean it up. But let's say a banana peel was there for 6 hours. The supermarket owners have to send people up and down the aisles regularly because they invited you to come into the store and buy products. They also are trying to bring your attention to the products. You're not walking with your head down looking at the floor. You're looking at all the displays they have, so it's their obligation to maintain the aisle. That would be constructive notice after a long period of time.
What is the standard liability of an owner of a piece of property as it relates, again, to somebody walking on the sidewalks in front of their building? You mentioned something that I think is very important. If there's 1, 2, or 3 family home that is adjacent to where the accident may occur, and what the ramifications of that are.
There is a non-delegable duty of the owner of the premises to maintain their premises or the abutting sidewalk in a safe, decent condition. That's one element. So if that was not maintained decent and there was a defect, let's say the uneven sidewalk, and you fall as a result of that defect, and you have an injury, you're entitled to compensation for your injury. So they have a duty to make sure their premises are safe. And if they don't fulfill their duty, you have a legitimate lawsuit against them. Now, there's one little quirk. New York, and I don't want to get into theory or whatever, New York used to be a contributorily negligent theory. That means if you contributed somehow to the accident, you would not be compensated. But thank God New York did the right thing. They made it comparative negligence. So you no longer would be barred from suing. But let's say, and they actually do this, the landowner was 80% negligent, you were 20%. So your comparative negligence was 20%, but you can still be compensated for 80% of what the jury finds.
What's been your experience in terms of a slip and fall? What percentage might be against the city of New York?
I don't know exactly, but it's a lot. The lawsuits against the city of New York are legion and many. The city of New York would do itself a favor and they could save a lot of money if they repaired their sidewalks instead of giving them out in lawsuits. Because wherever you go, I had urged Mayor Bloomberg to pass a law in Albany. I got it passed that would hold the abutting owners responsible for their sidewalks, which they should be responsible. They carry insurance for, by the way, except for 1, 2, and 3 family. So now the city is not responsible for multiple dwellings or for office buildings. They are responsible for 1, 2, and 3 family. If somebody falls because of a broken sidewalk.
I think it's important to note that you have a very significant legislative experience, having been elected both to the New York City Council as well as to the New York State Assembly. So that your experience in terms of seeing and dealing with these kinds of issues and also being involved in developing legislative priorities is very important. I want to talk again about your frequency based on your experience in terms of injuries that occur from your experience as it relates to slip and fall accidents.
I think that's a tremendous part of our practices. Basically, we as lawyers in the Bronx have mainly automobile accident cases or slip and fall and trip and fall because many people have to walk through a gauntlet of issues. You take the NYCHA building, the housing authority, if you have an uneven leveling of an elevator, let's say an elevator is down by 1 inch, you're looking straight ahead, you walk out, your toe hits the wall of the elevator, and you fall, you break a hip, or you go down a staircase, and the staircase is filled with debris, or there's no lighting, or there's no banister. If you're supposed to have a banister, you don't have a banister, that's a negligent condition.
You mentioned about the city of New York, and I think that it's very accurate. As you say, there are tens of thousands of cases involving the city as a defendant. Related to that is something called, and you touched on before, notice of claim. To explain that.
When you sue, and this is very dangerous, because some people don't realize, and some lawyers might know, you have to go to a lawyer that does negligence work like John Deary, who was also a legislator and has an excellent practice, and he will see what the situation is. If it's against the city of New York, and even if you think it's against the city of New York, and it's not, file a notice of claim within 90 days of the date of the accident. If you don't do that, you're going to have a big problem, because the law says in order to bring a lawsuit, you have to have filed that notice of claim. And on top of that, even though there's a normal 3-year statute of limitation against the city, you have to sue within 1 year and 90 days. That's a pitfall for lawyers, because if they don't know that, they can have a big problem. They could be committing malpractice.
What is included in the notice of claim that you speak of as being as significant as it is in the legislative
Well, it's
process?
very simple. Let's say it's a sidewalk. What I do with my notice of claims, I take pictures of the sidewalk and I attach the picture. And we in essence say that John Doe was walking up, let's say, East Tremont Avenue on the west side and was caused to fall by an uneven, broken sidewalk, and I attach the picture. It's one long paragraph, and that's sufficient. It's a simple document. They don't ask you to put your whole case out, but also the city has a right to question you. A normal case, there's a deposition, they only get one shot. The city gets two shots. They have a right to depose you as to the notice of claim, and then when you start the lawsuit, they can depose you again.
You made reference to a picture of the accident, and I personally think that that's extremely important. Talk about that in relationship to an individual who was injured and had a slip and fall of some cause, slip and fall, whatever. Why is a picture important, and what do you want to capture in the picture?
I know it may sound ghoulish, but it's very important to have a picture for several reasons. The picture shows the lawyer where it happened. Sometimes you could have fallen between two properties. You might have to sue both properties. It shows you what you can say in the notice of claim, and you want to attach the picture. If you can take a picture, and if you're level-headed enough to do it, do it. Otherwise, we send out our photographers to take pictures. And we always think a lawyer has to have one part stress, one part paranoia. You always want to get that done within 90 days. And the picture, whoever said a picture speaks 1,000 words is correct. A picture is a vital part of your notice of claim. Also, people helped you up. If people saw you fell, that's important because the city can't say you made it up. Sometimes the city will say, well, did anybody else see the accident? No, but that doesn't mean I want to emphasize, some people think because nobody witnessed the accident, they can't sue. Not true. You can sue and you'll testify as to what happened. But if there are people who saw you fall, that's very helpful.
You use a figure of 90 days, and I think that's very important for residents that are listening to this to understand the importance of that 90-day.
90 days is statutory, and unless you file, it's called a condition precedent. You can't bring a lawsuit unless you file the notice of claim. It had to be done within 90 days. If you didn't file your notice of claim, you're out. Sometimes you can make a motion and ask for forgiveness, but you don't want to rely on that. You want to make sure it's done within 90 days. You have to serve it on the City of New York. It could be served by mail or in person.
Talk about a construction site accident in which there was a slip and fall on a construction site.
Well, I'll tell you a story. It happened in Co-op City. This woman's walking in the sidewalk, and all of a sudden, in this story, the woman was 5 feet tall. She was tiny, and the beam falls right on top of her and knocks her down, even though that's not a slip and fall. But the problem becomes, who do you sue? Do you sue the construction site? Do you sue Co-op City? You wind up debating what happens. Constructions, let's say the construction company actually caused a defect. They left too much gravel in the road. You fall in the gravel. It's the construction company. So you really got to do footwork to determine who's at blame. Unfortunately, many times lawyers must sue several people until they find out who is to blame for the accident. But you have to do that to protect your client.
I just want to go back for a second to the picture. Describe what it is that a person who might have been injured wants to take a picture of what the defect was. What should they be thinking about, and what kind of picture?
Okay, if I go out and take the picture, sometimes I do it because I like to see where a person fell. When I know where a person fell, nobody can BS me. I got it in my mind. You want to take a long shot to show the defect from a long point of view. You want to take walking towards the defect, walking away from the defect. You want to take a close-up showing the actual defect itself. So take as many pictures as you need. Don't be cheap with the pictures. Take all different angles. Also, you want to take a picture of the address of the home, a long shot from the gutter facing the home, so you could show how the sidewalk abuts to the home. So you want to take as many pictures as possible.
Do you find that people, based on your experience, that have been injured, do you find that those who have taken the time to take a picture, are the pictures beneficial?
Yes, but many times, even though they're taken, we send out another photographer because we want a professional shot of the defect. But the fact that you took a picture is very helpful because sometimes somebody could patch up the defect and we don't know what it looks like. With the picture, you know exactly what it looks like.
There are falls in ice and snow.
I was going to mention that. Let's talk about ice and snow. The law in ice and snow is peculiar. And if you get confused, I understand. A landowner, including the city, has to make their sidewalk safe for you. Inside the premises, they should have mats if people are taking in water from the sidewalks. Now, the landlord has a perfect defense. It's called storm in progress. So if it is snowing and you fall, you're out of luck. Because what are they supposed to do? It's snowing. They have until 4 hours after the snow to clean up the snow. From 9 p.m. to 7 a.m. in the morning, they don't have to do anything. So that is the law on snow and ice. Now, a trivial snowstorm could still be a snowstorm. A storm in progress could be a snowstorm, stops a little bit, a little later, it still can be considered to be a storm in progress. Let's say it snowed a week ago and there was ice. Then it snows a week later and the snow covers the ice and you fall. They're responsible because the ice underneath the snow is what caused you to fall, not the snow in progress. Now, that basically is the story with snow and ice. If I confused you, I'm sorry. Sometimes
No, you didn't confuse it, but you put a lot on the table. What happens if the person has an accident? You made reference to time periods. What happens if they had an accident at 9 o'clock at night?
well, we would bring a lawsuit anyway, but they're exempt from cleaning from 9 p.m. to 7 a.m. But let's say
it happened at 10 o'clock then in the evening.
they have the time. You know, I'm not here defending landlords, but nobody expects them to be out at 10 o'clock at night shoveling the snow. And that's the thing with storm in progress, because you can go out and shovel snow and then the snow could be still coming in. And if you have 15 inches of snow and you fall 3 days later, I don't think you'll be successful in a lawsuit.
So are you suggesting that a snow and ice condition complicates a slip and fall case?
Well, it's a different kind of liability because you're talking about snow and ice. If there's a defect, an uneven sidewalk, and there's snow and ice and you fall on the uneven sidewalk, that's what caused you to fall. If there was ice from a week ago and the landowner did not clean it up, well, he's still liable even though it's snowing. Because the snowstorm that day didn't cause you to fall. It was the ice that he left on the ground.
Statute of limitations, very important for people to understand.
3 years you have. Don't wait. If somebody comes see me and it's 2 years later, I may not even take it. You got to make up your mind. If you're going to sue, do it early. Don't wait. The city of New York, remember, is exempt from that 3-year statute of limitations. 90-day notice of claim, and the suit must be brought within 1 year and 90 days. Other than that, it's a 3-year statute of limitations.
So you're saying that if a person is injured as a result of a private defendant, they'd have 3 years to bring the lawsuit.
Yes.
You're saying if it's against the city of New York, they have only 90 days?
Notice of claim, and then let's say you file the notice of claim in time. You have to start the lawsuit within 1 year and 90 days from the date of the accident.
Have you experienced situations where, and I think frankly it's a rather unfair situation for the average person that has an injury, doesn't realize it's the city or the state involved as a potential defendant, and it's not 3 months later, but 6 months later, and they have no case?
Well, you can make a motion, and they're frequently granted. It's not an impossible bar to obtain. But I agree with you. I think all these statutes drive you crazy because how do people know these? As you just said, how do they know it? They don't know it. But if they see a lawyer within 90 days, I had people come see me the 89th day, and we ran and had the notice of claim. The good thing is you can mail the notice of claim. Once you mail it, it's considered served. So,
And to whom do you mail that notice of claim?
the control of the city of New York.
And what is it that the City of New York controller does?
He contacts the Corporation Council, and they set it moving.
What has been your experience of recent years with regard to the City of New York and the Corp Council?
I find them nice to deal with. I know that maybe some people may find it different. I have my own approach to dealing with things. I try not to be obnoxious. I try to be able to work with my opposition. We're on the same planet. They're not my enemy, and I try to resolve it. You want to try to settle a case. Going to trial is very costly. And also, the courts are moving very slowly. If you wait for a trial date, it's going to be a long time. Sometimes you have to go to trial because you have to show the other side you're not afraid of going to trial. But if you can settle it at a reasonable compensation, I highly recommend that you do it. Don't be a hero because it's that person's money. Your lawyer may have 100 cases, 200 cases. If they lose the case, they move on. If the client loses it, that's their recovery gone down the drain. And by nature, slip and fall cases are not so easy because the fact that you're walking along, you sort of in some way contribute to the accident. Let's say you're a passenger in a car, and somebody comes speeding down, hits your side of the car and injures you. You did nothing wrong. You were a passive person in a car. But when you're walking, they'll say, well, why don't you see where he's going? What kind of shoes did you wear? Let's say you're wearing high heels and you're walking on the sidewalk. They say, why are you wearing high heels? So there's always an element of contributory negligence to slip and fall and trip and fall. So if you can settle it at a reasonable, fair amount of money, I suggest you do it.
You have the opportunity when you put a case into suit to ultimately go to a trial. But there are other alternatives and other procedures to be able to resolve and settle a case. And one of them is mediation. Do you do much mediation?
I think mediation is the best thing to do. If a lawyer doesn't do mediation, he's an idiot. Not arbitration, mediation. What happens with mediation is many times you can settle it. If the other side wants to mediate, it means they want to settle it. I mean, usually they're not playing games. So you get into a room with a mediator. Many of them are ex-judges, and you sit there for 3 hours usually, and you go back and forth. You find out what they have against you, and you find out what they find out some of what they have, what you have against them. And I think mediation is wonderful because the courts are very slow and enables you to speed up a settlement. You don't want to wait 5 or 6 years to resolve your case. If you could do it in 2 or 3 years, you're better off. You ever hear the phrase present value of money? Better off having your money 3 years now than 6 years from now.
Why do you think the courts are so slow in terms of getting to either resolution?
I don't want to tell you the truth, but I think that the courts have to manage themselves much better. And also, the courts are obligated. We're talking about people's rights under a constitution. You can't slop off a person's constitutional rights, whether it be criminal law or civil law, to have a fair trial. And negligence cases are cumbersome by their nature. They have a right to examine you to see if you're telling the truth about your injury. They have a right to know what your theory is of the law. And the courts are backlogged because they have so many cases on the calendar. You know, we live in a very litigious society where people are bringing lawsuits, and the courts are bombarded with that every day.
What do you see as the difference between the trial in a court situation and mediation as it relates to what percentages of cases that you ultimately resolve from your own experience, more or less, go in
Well,
either
there's
the
another
court or the
problem with
mediation?
trying a case. If you try a case, you have to pay a doctor to come in. Doctors charge you $10,000. You also might need an expert. What are they going to charge you? So immediately you're spending money to bulk up your case. And because your trial, you're waiting online forever. Now, a trial is necessary if you think your case is worth $1 million and all they're offering you is $5,000. You got to try the case. But let's say mediation, you don't need an expert. You can have one. Sometimes you should. You might need an economist. You need a doctor's report. But you don't need, it's not formal. Nobody's testifying. It takes the burden away from the client. They don't have to be nervous about appearing in court. You don't have to line up all your witnesses. And it's just a quicker process.
What do you think is the percentage of cases that you're able to resolve, mediation versus court?
Well, you settle cases in both places. You try to settle them. I would say that 80 to 90% of my cases are settled in mediation. Sometimes you get some that you're just too far apart, or what happens is you have to come back again, and you come back again.
What do you think is the typical client who was injured and has a case and is with you and they're now moving towards a court or a mediation?
I'm glad you brought that up because the client is very important. Clients of the world, if you're listening, they used to have a statement in the past in the Bronx called a yenta, a busybody. Don't listen to your friends, listen to your lawyer. You don't know what a case is worth. You can come in and I get this sometimes and it drives me nuts. How does the person know that his case is worth $1 million? I mean, who told him it's worth $1 million? John Doe says, I got $1 million. You know, you may read somewhere a case went to trial and they got $1 million, but you didn't read about the appeal when they might have lost or was reduced to $500,000. Please listen to your lawyer. If you don't like your lawyer, you shouldn't have hired him. You really can't come in, and you have a right to input. You have a right to your opinion, but you got to be careful. Don't challenge your lawyer if there becomes a really heated dispute as to what a case is worth, because the lawyer has hundreds of cases. They've read books and articles and everything, and they have a better idea of what a case is worth. So in mediation, the client, you sit down and you try to come up with a figure that you can both agree on, but usually you come up with a range. You can't say, well, this case is worth $100,000. Maybe it's worth 75. Maybe it's worth 125. Maybe it's worth 100. You don't know. When you go to mediation, you try to get the most you can, but it should be within a parameter both of you agreed on.
We touched on an awful lot on slip and falls. Is there anything that strikes you that maybe we didn't touch on that might be worth conveying to potential clients?
Well, I'm racking my brain to try and think. I think we really covered it completely. I urge you, when you hire a lawyer, to trust that person, to work with that lawyer, and to get along with him. I get along with my clients. You need to get along with your lawyer. And be careful. I can't overemphasize this. Don't talk to everybody in the street. And sometimes, and I don't want to make you paranoid, the other side may hire an investigator to follow you around. Very rarely does that happen, so don't go crazy. But so I had a client who did stupid things, an investigator. Thank God there was no investigator. But you have to be cautious and don't discuss your case with the whole world, because you'll get people that will have your head spinning in circles.
Steve, you brought a tremendous amount of experience in this field of slip and fall. And by the way, I'm very much aware motor vehicles, construction site, and all other kinds of accidents are things that you do every day. And so to share with us on this particular topic of slip and falls, I thank you very much.
Thank you for having me here tonight.
Great to see you. Thanks, Steve.